So you can't even begin to talk about 2/3 on something that is not even in the Constitution. In the circumstances, honorable members, I rule that our decision, clause by clause, will be by the majority present and voting. Yes, leader of the opposition.
I so much respect you as a person. And my position has always been that we are living a lasting memory as a nation. This parliament is making the history, and we're on the side totally convinced, we are extremely persuaded that you cannot change peace to wars and off to act in this constitution by mere simple majority. With every respect to your ruling, sir, as stated in SO 42, I want you and the general public, the entire world, to note that we on the side will not be a party to advocating or going against the standard of amendment. We have supported various reforms brought to this house. If we are not willing to support reforms, we will never have voted today. But what we did was an expression of our total willingness for government. But our willingness does not mean we should do what we consider as unlawful. So, Mr. Speaker, with all due respect, sir, pending on your ruling, we want the entire world to note that 96 honorable members of parliament are seeking to amend a document that is to be amended by 100 members of parliament. So we on this side cannot be a party to that, Mr. Speaker. So, honorably, sir, with all due respect, sir, I respect your office so much. I respect your office so much. And in fact, I am constrained because of the respect I have for your office. We on this side will honorably, with all due respect to your seat and with all due respect to this parliament, and the people of Sierra Leone who are watching us, people all over the world, we on this side will not be part of an amendment that lacks the threshold of 2/3 majority. So on that note, we are leaving the ball in your court. 96 members. If you want to touch the constitution, we have the army for posterity.
No problem.
Posterity will hold you responsible. So on that note, I ask my colleagues on the side that we take a peaceful leave and leave in 96 members. Yes.
Yes, thank you.
Let's listen to yes. Thank you. Okay. So we are going to start.
It's all right. Honorable members, please occupy your seats. Occupy your seats. I'm going to do a ruling. I'm going to do a ruling on this subject, and I'll refer the matter to the Supreme Court for review. Can we proceed with the other clauses? Proceed with the other clauses.
Mr. Chairman.
Yes.
Mr. Chairman, so
Go to the age thing on page 3.
yes, page 3 on the age.
Yes.
I think the aging made the proposal during the debate. Order, please.
Order.
Mr. Chairman, however, we have moved the age attached to whose qualification.
Sir?
I said, if we are putting a term of 2 years, of 2 terms, you should only qualify to be a commissioner if you attain the age of 65. If you attain the age of 65. We cannot use 2 bars in most legislations in conformities with the law for us to put 2 bars at the same time for one provision. So I'm moving at instead of we said he has not attained the age of 65 years, running down to B of that one. If he has not attained same provision under the member of the Electoral Commission, unless he has attained the age of 65. So we are saying,
Okay, we'll leave it as it is.
you can only qualify. I've done 2 submissions.
What do you
You can only qualify to be a commissioner if you have attained the age of 65. That is one. But we are now, I'm now introducing another clause
Yes.
that you have a term limit
The time limit
of 2 years.
of 2.
Yes. So I now
Take note, Mr. Minister.
Mr. Minister,
Can you move? Can you move?
yes, we move that you can only qualify to be a commissioner if you attain the age of 65. That is one. That will come to the rendition.
The rendition will be done properly. Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. We proceed on page 4.
Mr. Chairman,
Yes.
we give you the rendition for. I want you to be consistent with other provisions like the
Of course.
agriculture.
We have just passed it. We have just allowed it in principle.
In principle.
Yes.
So we come back to other rendition. I will pass
Yes.
it. Okay,
Proceed.
thank you.
Proceed. Proceed. Page 4.
Yes, okay.
And okay, on page 3, there was this provision relating to if he is not a member of a registered political party. Are you maintaining that? If he is not a member of a registered political party.
Chairman, that causes no harm. We put it just to enhance the process of legislation to qualify, yes, registered. What I think we have to do, because there is a clause that the PLC have that has to do with a registered political party and an active political member. So we are going to put a registered political party. We will check that one with the drafter. Thank God the drafter is here.
Okay.
Because they are speaking to 2 different languages. So as a registered political party, I think we consult the drafter and we'll come back to that. But definitely we have to state it. Yeah, thank you.
Yes, Mr. Minister. Is that correct?
Yes, Mr. Speaker, Honorable Members.
Yes, again, whilst I agree, Mr. Chairman, I'll kindly agree with the Honorable Leader of Government Business whilst we're looking at that particular rendition, we also consider, because sometimes it's difficult for you to even prove membership, we can talk about engagement in partisan activities.
Okay. Is all right. Is that noted, honorable members? Okay. There's page 4.
Chairman, I was expecting Mr. Minister would agree that if the masters for the qualification that if you have a postgraduate from a recognized university and has that is a chief electoral commissioner, unless he holds a postgraduate degree from a recognized university, 1, woman 2, has a professional qualification and experience in governance and public sector at least for the chief electoral at least 5 years.
Yes, we did that amendment.
We did that amendment, right?
10 years.
Yeah. Is it 10?
The others are 5 years.
Clear. Oh, the others are 5. And also for the bachelor degree, when you talk about postgraduate course in the chief electoral commissioner, you can act in that capacity at any time. So why not just say the same qualification for the electoral commissioner? For the electoral commission, unless he holds a bachelor degree of equivalent from a recognized, I think I want to be consistent with the law. For the SPSS, the qualification for the National Security Act, there is a difference in qualification with that of the NS4 and deputies, even for CISA. So we said no, you can act in that position at any time. For the experience as we have done here, I can understand. But because you are going to act and it has to do with some level of efficiency and professionalism, I believe that that has to come to the level of qualification in terms of degree. I think they should have a say for a consistency sake in enacting the law. Okay. That has been my position from what's there been my submission today.
And under clause 3, we were supposed to have inserted 61. Amendment of 61.
Chairman.
Yes,
Chairman.
Yes.
Yes, I just want to make a quick comment on the recognized university aspect.
Yes.
So I don't know, there are some universities that are recognized, but then they are not accredited. So I don't know whether we say accredited or just recognized university.
Honorable member, before the chairman comes in, I don't think this is something we have to belabor on, because we've had provisions that clearly spells out when it comes to the qualification in terms of how we use that particular aspect when it comes to universities. I don't think that will be a problem. Thank you.
Honorable members, I think we don't need to engage in further debates. Let's go to the issues as they are, because I don't think there is much contention right now. We just go to the issues and move.
Mr. Chairman, let's be honest. Let's just put this clear. We have legislation for different institutions. They are part of. We have to understand, so we cannot come back to it.
Of course.
We cannot do the administration of the law.
Of course.
That is why we have other subsidiary legislation. But there is a reason I asked the minister for 108 in terms of fixed election dates. He made a pronouncement that yes, subsequently, those legislation will be in front of all the PLC Act, the Public Elections Act, and also with the provision for the for regulations. So those things have been taken care of. The University Acts are there. Whether you are accredited, there's a whole lot of criteria you have to go through for it to be recognized as whether recognized university or not. What we are interested in, when we are doing our vetting, we now ask the relevant institution to prove to us whether you're coming from a recognized university or whether it's not no more university together. So those things can be there. Thank you.
So we are on page 5, not so?
All right, okay, I can.
No, of course, that one goes through. Maybe the rendition will now be done. As long as we've agreed in principle. Page 4, page 5.
Well, in page 4, you know, the other day we discussed the issue of staggering when it comes to appointments. But the essence of that was not to allow the appointment to commence at the same time, to ensure institutional.
We agree.
Yes, but what's not clear, I think the terms. It came up. You know, yes, a commissioner shall serve a full term of 5 years from the date of appointment, irrespective of the remaining terms of other commissioners. That's the end of it. There is nowhere that talks about even reappointment. It's only a term of 5 years. So again,
that can be started by proper.
yes, again, because we've had that for another term of 5 years, like normally you understand reappointment.
Okay. That is on 4 also. Mr. Minister, take note of all of these issues.
Yeah, Mr. Speaker, I'd like to make some correction or something.
AG, before, in fact, my attention has been drawn to by the clerk that it was even inserted on that page.
Yes, certainly.
Thank you.
Certainly, Mr. Minister. So we proceed to page 5.
Mr. Speaker, before we proceed to page 5, with your leave, because of the modifications that have been made, section 32, subsection 4, we propose that some rewarding is done, especially relating to the age of 65 years. And what I've gathered from honorable members, the intent is that if someone has attained the age of 65, then that person is not qualified to be appointed, emphasis on the word appointed, Chief Electoral Commissioner. However, based on the submission that has been made and as approved by members of Parliament, if someone is already appointed for a time, and then in the course of that time, that person turns 65, he will still continue to hold that office until he or she finishes that term. Because the reading of it now, B, says a person shall not be qualified, B, to hold office as a member of the Electoral Commission, of the Electoral Commission, if he is a minister, deputy minister, member of Parliament, or a public officer, or if he has attained the age of 65 years. So which means, if under current law, if you turn 65 while serving on the commission, you cease to qualify immediately. So the proposal will be for subsection 4, no, subsection 4 of section 32, to read, a person shall not be qualified for appointment as a member of the Electoral Commission, A, if he is not qualified to be elected as a member of Parliament, and B, if he is a minister, deputy minister, a member of Parliament, a public officer, or if he has attained the age of 65. So that way, that restriction, when you're 65, applies to appointment, not service. That would be the amendment.
Mr. Justice.
Yes,
So in that case, the issue of reappointment for such a person is null and void.
Are we set on that?
Yes.
Are we set?
Yes.
Mr. Minister.
Yes, Mr. Speaker, we have taken note of the correction. We just wanted to provide that clarification.
Okay, sorry. Yes, so we move on to page 5 also. Page 5.
I think in page 5, it's the subsection 2 was where we stopped, which of course I strongly believe the leader
On
of
page 5? No, we don't have 2 on page 5.
Or B, I mean B, the B aspect.
Mr. Speaker, if I may,
It's the B aspect.
Oh, yes, no.
Mr. Chairman. Exactly.
Yes. Yes. So it's
So I agree to go with the stand law.
Yes.
Yes.
Thank you.
And under clause 3, I think we changed 2 to 1.
yes.
We changed 2 to 1.
Instead of
Then
subsection 2,
I think
it's
under the
subsection
proviso, we did an amendment by the insertion of 61 or 61 or something like that. Am I clear on that?
Mr. Chairman, first, let us do an amendment for the 30%. Not only the proper rendition, but we all accepted that we should have the 30% as enshrined in the Kiwi Act. So we should just import that one.
Yes, that was what I agreed. And I think there's something related to the executive. Not
Yes, so we are here to
Mr.
ask the minister.
You have to guide us.
Yes.
Yes, please.
Just a minute, let me come. We need to have it in the proper order. This one has to do with elections. This one has to do with electoral laws. Yes. The one that has to do with the executive, we are saying this where we have 61. So it should be in the next page. It should be the other page. So for this, we sustain 30% as the given act. So the thing I want the minister to clarify is going to carry the word shall as proposed.
Yes, Mr. Honorable members, for
We still want to have you on that.
for section 35, we will keep the word shall, and for section 61, will be made.
Okay.
So the
That's on
submission,
page 5.
yeah. So your submission is still in line. Is still in line with only the 30% party nominees for national and local government elections shall be women.
Correct.
So the subsequent provisions in the Public Elections Act they remain the same. We don't touch that one at all. We import them. You know,
Well, yes, the only thing is when we get to that, we will propose an amendment to section 58 of the Public Elections Act.
so we don't need to go far. So if you accept this one, we now go to Public Elections Act and do the subsequent amendment because you have said I will also to sit in line with section 58 of the Public Elections Act. So here we maintain the word shall, Mr. Chairman, and we rely on the Public Elections Act to entrench to make a clarification in section 58. Okay. All right.
So is that noted?
Yes, sir.
Then we move on to page 6.
Mr. Chairman, please.
Yes.
I'm not a lawyer, the lawmaker. I just want some clarification.
Yes.
It's simple. One person representing. What is the difference between the two? When can the president appoint without making reference to any group? One person from.
Where is that?
Those days.
Well, Chairman, I think he's talking about his search.
No, we are going to that.
On page 5.
No, we are going to that.
Measure the language I'm talking about.
No, forget about the language.
Okay. Thank you.
There is no way I intend to do a job, sir. Once again, there are certain areas where they are able to, you understand, no need to go for them. Just like we draw our attention to the areas where we stock pins, and those areas have been highlighted.
Yes,
page 6.
Chairman, Mr. Chairman, sorry, sir. I beg to differ. Those questions are not. Those questions we are agreeing on principles. So what we need to do for the edification of the public, we have brought in all of those provisions. We seemingly agree, but it's also force of law. So we have to state it. Especially our work on that we agree on those provisions, on principles. So what we are doing now, we are taking our time to go across like stop keeping on them.
Yes.
So I'm now
saying
we have dealt with all of them that
all
we
of them.
61.
Yes.
Making term limit for electoral commissioner. And what we are proposing, that we said, attend it because we say you cannot put too back. The qualification should be the same. And the year of 10 years and 5 years. I remember,
yes,
we agree on those things.
Exactly.
Right? So we have to go over it so that people understand. We agree on them.
Of course. So page 5 to 6. Page 5 to 6.
Page 5 to 6. There is an area, the top part of that's section 4, the A and B, there we stock pins, the C and D that had to do with the census, we are finding that. So it was the A and B aspect that we are going to look at, because talking about the aging as well, talking about moving the constituencies in the recommendation aspect, the A and B, those are the areas that we stock a pin on.
So are we okay now with them? Because there's no more contention. You don't have much contention. So are you okay with that? Leader of government business?
Yeah. Yes.
So those provisions stay. Okay. Mr. Minister, the provisions stay, not so?
Yes. Yes.
Page 6, page 7. We deleted the independent candidate, not so? Yes. And okay, so we are done with page 7. Page 8.
Well, it's clear that in page 8, E, that's where we have the issue of the threshold.
Yes, the threshold.
Yes.
But there is no more contention.
Well, the age,
Maybe Mr. Speaker, I'd just like to clarify. I think we made clear and as well that yes, in the bill, we had made a proposal for a threshold of a simple majority of total valid votes cast throughout Sierra Leone, and then to a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
But I think you agreed.
Yes. Yes, I just wanted to make clear to everyone including listening public, that we are agreed with the technical committee made up of the APC and government of Sierra Leone that the amended bill on the floor of this house is to read that a person shall not be declared elected president of Sierra Leone unless at the presidential election he obtains a vote of 50% plus 1 of the total valid votes cast.
50% plus 1.
Yes.
Okay.
Of the total valid votes cast. So and that removes the threshold and
so 50 plus 1.
Plus 1, yes. Okay. Plus 1.
Yeah, Mr. Chairman, this is in line with the tripartite recommendation.
Yes.
So the one we have in the bill, and we have the tripartite, and this is in line with the white paper in June 2017. More than 50%. Everything is in line. So what we are saying now, because tripartite is so recent and it's in conformity with both of the provisions, so we forget about the the threshold, district threshold, and stick to 50+1. Now let me be a little case for the public. If you go to section 42E of the Constitution, the first phase, the proposal we have, what is the extant provision, is 55%. And if there is a runoff, there's a runoff. F of that provision, section 42, subsection 2F, say it's going to be simple majority in 14 days, because you do elections in 14 days with simple majority. So there is not really much difference, I see. But this one is more entrenched, it's more classified in terms of reaching out to other political parties. So some of us will receive another provision from DPR, from APA, that there's a situation where you will not get the 50+1. What happens? So we are saying for national inclusivity, because we have argued on that
of course, if the law says 50+1, if you can't get 50+1, then you do runoff. Then there's runoff.
So in a case where,
and in runoff, the one who scores the highest wins.
It is simple majority. So there is a proposal also that instead of going around doing runoff, what about making the coalition with other parties that will give you 50+1? Yes, so you should not do runoff. That was the proposal from the APA, from all political parties. That was the proposal. So if the AG, so we need to discuss it. Mr. Chairman,
yes.
Then the proposal from APA.
AG.
So if this house says,
is it not 50+1, and in the event no political party scores the 50+1, there will be runoff? Yes.
Yeah, and Mr. Chairman, repeating this particular section by bringing in the tripartite recommendation, fair enough. We realize that tripartite recommendation, both parties were there, and the presence also of international community. We very fair enough to import tripartite recommendation to this bill now. And by repeating this today, I think we will join the rest of the world. The entire ECOWAS, as a member of ECOWAS Parliament, I realized that right in this supplementary act, Article 40, subsection 2, is saying countries should endeavor to have uniform laws. I think it is only Sierra Leone that is still going with 55% to make a president. But all of the ECOWAS countries, do your research, they are all 50.1 or simple majority. In fact, to the extent of even 54 countries comprising the AU, all of those AU countries, they practice 50.1 or simple majority. So repealing this age-long draconic law today will help Sierra Leone to join the rest of the world. I so submit.
Yes, proceed.
Mr. Chairman, I also just want to clarify that with this proposal, and because adopting what the federal government said, so this proposal, just to be clear, that yes, the 50+1 threshold, which will read, no person shall be elected as president of Sierra Leone unless at the presidential election he has polled a total of 50 plus a minimum, but not less than 50 plus 50% plus 1 of the valid votes in his favor. And so the threshold which we see under 2 of that clause will go away completely.
Of course, we have stated that.
Okay. And
I think what the leader wants to know is in the event nobody scores 50+1.
The government has to be done. The government's position on this, for for now is in the default of a candidate being duly elected under the provision that I just read, the two candidates with the highest number of numbers of votes shall go forward to the runoff.
More realistic.
All those in favor say aye. Aye. Those against say nay. The ayes have it. Proceed. Page 9.
Mr. Chairman, just
Page 9.
for neatness of proceedings, it's just clear that this aspect, the bottom part of page 8, way to the top part of page 11, we agreed to take all of that to the public elections.
That is very correct, Mr. Speaker.
Yes, all of that. Yes, we take all of that. So that should be the bottom part of page 8, page 9, page 10 also.
In fact, to the top part of
page 11.
Just above clause 8.
Yes, we agree. Okay, thank you. Now, the remaining part of page 11. Yes, under this one, we said to which the state is a party. But we decided to remove that to say any criminal.
Yes, to delete that aspect to which the state is a party.
No, not the state. We removed that aspect.
Yes, that's what I'm saying.
And we made it general.
Yes, sir.
Mr. Minister, take note of that. That's for page 11.
The text of this one that you are seeing.
We said in 43, in the event that the presidential candidate is standing trial on a criminal charge, we delete to which the state is a party. Delete that one, to which the state is a party. On a criminal charge 1 year prior to the election. So we just delete that. So it becomes general, whether private or state prosecution.
So we know the state trial is suspended.
Yes. Yes, after 1 year. That's for page 11. Page 12.
Mr. Chairman.
Yes.
Yeah, just a clarification. So this goes for purely presidential candidate, not their candidates.
Of course.
Fine.
Yes, page 12.
Page 12, remember the top part of page 12, which has to be, was deleted.
Yes, this one was deleted. Delete?
Yes, the top part, yes. And also,
we deleted 10.
In fact, 10 was the transitional provision, and we deleted 10 to the top part of page 13.
And we deleted president or
yes, because that provision has to do with the vice president, so the word president there was redundant.
Yes. Then under 12E, we deleted expulsion.
Expulsion was replaced with his removal.
So under clause 13?
Well, 13 at some point had a contention for some reason. Again, we can go back again to the age we stock a pin on clause 13.
On 13. AG. We have dealt with that. Yeah, we have dealt with that. Yes, AG, 13.
Sorry, Mr. Speaker. Can you please go over that? Can you please go over that?
Well, I was saying.
There was contention to the proportional representation.
Yes, that was clause 13. That was the only area where we stuck a pin. Yes. The other areas had to do with removal of the vice president, but the president was inserted and we deleted president.
Yes, we deleted.
Yeah, yes, please.
No, we are on clause 13.
So yes, I'm just taking it through.
Yes, Speaker. Yes, we keep the proposal to amend Section 74 of the Constitution to read B. Such number of members of Parliament as Parliament may prescribe who, subject to this Constitution, shall be elected through a system of proportional representation. And then we have included an additional link to say with a detailed mode, method of nomination and conduct of such elections prescribed by or under Act and Act of Parliament. And Mr. Speaker, with your leave, I'd like to just provide some context on that,
yes, please.
that additional link.
Yes,
yeah, that is what I...
Well, of course.
No, so
then what do you need to explain now?
You are going to bring that.
What do you need to explain?
So I'm just trying to provide. So of course we want to keep the link of that the detailed mode and method of nomination be prescribed in a separate legislation. I think we're on the same page on that. I just wanted to say, if required, I'm happy to provide context on why we recommend that. But if members of Parliament, already have the context that such prescription will be made in a separate law, and we will have a conversation on such proposals. We are happy to lead the conversation at that.
Yes. So on page 14, page 15.
Mr. Chairman, on page 14,
yes,
we stock a smaller people, in the sense that we have to agree on the safeguards.
Yes, the safeguards. Have you done the regulation for the safeguards?
Well, to some point.
Yes.
Because
read them out.
One, with regards, we have to agree on something because it will affect changes in some other areas, which we have to look at. I'm going to understand. At some point, we'll have to revisit 41. We'll have to revisit 54 because 41 the qualification for president, 54 the qualification for president, also on that particular aspect. Then 56 to 60 ministers. Then 75 to 77 members of parliament. And then, to some extent, even if possible, the Citizenship Act was to fall under consequential provision. So, now, we're going to settle on something because it's going to be clear that certain positions, which were already clear on that day, the president, the vice president, the speaker, the chief justice, those areas are prevented from that particular change. So let me read something as part of the safeguards. A person who is a dual citizen shall be ordinarily resident in Sierra Leone for a period of not less than 24 months, immediately preceding the date of nomination for appointment. Other safeguards, we talk about NASIT. And then also on that day, I also raised the issue of disclosure of all foreign citizenship, which was very important because if we consider here as a dual citizen, we don't know the other nationality which we held again. Of course, disclose any foreign public office.
I hope Mr. AD, you are taking note. And Mr. Thompson is here also. Take note of all of those issues.
Yes, Mr. Speaker, we did take note of all of those, and I think we are on the same page.
Yeah, do a proper rendition to reflect that.
And
Mr. Chairman,
yes.
It's clear that he made a lot of proposals that were making it confusing.
Oh.
The chairman. Yeah. So I was thinking I should have given us a new edition, putting in place like the layout, who to propose, president, vice president, chief of parliament, dealing with different council, take another category. That's to do with other activities. We are proposing chief immigration.
You can use a legalese. Instead of having those, you can use a legalese to reflect the position in all of those sections to refer to. Notwithstanding what is in that. So
because
like that.
The chairman, we have to be very careful in dealing with this. Don't forget that there are other discussions.
Yes.
And this one we have to maintain. We should be here. Especially if we don't carry lives. We have to maintain that constitution. Why? The non-chief of No, it's just the proposal I'm making, not that I'm making submission. I'm still in line with what you are proposing. But I want us to be clear on the text provided to us. If you read the text, it's very clear and voluntary on an end declaration of allegiance. That's what you are, and that's what is in line, the spirit on why we are changing to the 6-1. So if you categorize them as we started, for the other categories, so be in line with other existing legislations, it can be fine. I don't want us to go too deep. Yeah, I mean, at the end of the day, if you're talking about to be a association for voluntary, you want to be ministers, you have to go and make an amendment. You know that very well, Mr. Minister. Oh yes, I'm drawing attention. You have to make one amendment 56. So you have to accept it, you have to have a revision, and go back for 56. Because you cannot be a member of parliament, you member of parliament. So if you are making exceptions, you have to go for 56. If we want our brothers in the diaspora to be part of us, we have to be there. We have to be careful. We deal both sides of the eye.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go prepare a proper rendition.
But I have clearly talking about what you told us. Those ones was too much in this one, like on any, and it was making it too naive for us to put those things in the constitution. What I'm just saying, which are me, in principle, that let us go back and look again, we all agree, because this is not about us. This is about our own family members who are what has happened, because as a son of our family. So what she said that you now look at the legislation, with other legislation, so we cannot mix them up. So that when we come, we now put them properly in place. Go into the constitution. So that is it. Okay, thank you.
Yes, all those in favor say aye. Those against say nay. The ayes have it. Let the rendition be done.
Clarification, Mr. Chairman.
Yes.
Yes, the rendition is going to be done. But I just want again to make it clear that I mentioned the four positions. Any others could fall into some of the legislation. I list them all. So let's really be clear on that particular aspect.
So what we have agreed on the rendition, make sure I see it.
Yes, again,
the rendition and bring it, let me see.
Why I'm going over this again, I mentioned the position, the president, the vice president, the speaker, the chief justice. The day I made the submission, there were some other positions. But again, the House never accepted Mr. Sokoto. But we have to bring, because I raised a point about the Inspector General of Police, the Chief of Defense Staff, and many more. So let's be clear that day I made a submission, it wasn't accepted. So we have to provide safeguards. We are talking about 24 months.
This is a position that was accepted. It was an accepted.
And in fact, I also, the honorable leader is busy there. I raised, or I highlighted the provisions that we will release at some point, together with the draftment, of course, 54, 41, and then 56 to 60, and all the rest of it. Again, I just want to be on record.
Mr. Clark, take note. Mr. Clark, take note of that.
Sorry, I think, Mr. Speaker, honorable members, I think for government in the submission last week, unfortunately, I left a piece of paper where we had proposed the rendition for Section 76. To my file, it's not here. But our proposal was to add a proviso under Section 76 to read as if a person, something actually, and I have worked on it, just don't have it. But we basically say a person who is a Sierra Leonean by birth, but holds the citizenship of another country, we put it in the context of the negative. It shall not be qualified to run for election as member of parliament unless that person has paid local taxes to the community for 5 years preceding their candidacy for such an election, and that person has been physically resident in Sierra Leone for a period not less than 24 months. And then we provided additional language to say that such a person shall not be qualified to hold office of president, vice president, speaker of parliament, and chief justice, because these are all positions in line with the presidency. Any of these persons can act as president at any time. But for the other positions that were suggested, I think, Mr. Speaker, honorable members, I laid out with concrete examples why we would design ourselves in ways that will affect us in the future if we attempt to extend such a restriction to other positions, including Chief of Defense Staff, Inspector General of Police, noting, as I said, that we have had foreign nationals holding offices before, or that Sierra Leone national has served as Chief Justice in another country before, or in that country, their constitution doesn't provide for being in line to act as president. And then, of course, other examples about the governor of the Bank of Sierra Leone provided an example of the current Prime Minister of Canada, who was the governor of the Bank of England, etc., etc. So, noting that Sierra Leoneans by birth who will hold citizenship of other countries, but might have significant contributions to make to various sectors, and at the particular time when they might be the best fit to serve in these positions. Our submission, Mr. Speaker, honorable members, is that we should not restrict ourselves too much. But for government, we are very happy keeping these restrictions to the positions that we have highlighted, which is one, such a person will not hold the office of President, Vice President, Speaker, and Chief Justice. That is the submission.
We should also be united. We are needed for to allow all of us to serve as speaker, and then the way we are going to make the law to guide members of parliament to become speaker. Because, for instance,
not members of parliament, who are citizens.
No, the fact that the person is qualified to be a member of parliament, they should be qualified to be
It's like saying the dual citizen can become the president.
It's like, why are we allowed?
Do you accept that?
They are members of parliament.
Hold on, do you accept the dual citizen becoming the president?
No, he's not a dual citizen. We are also saying that members of parliament, we should have two categories of members of parliament. We have people who are dual citizens and people who are not. And this is the section 78 of the Constitution. It said that members to be qualified speaker.
So you are against it?
Yes. So if you are a member of parliament, you should be qualified to be elected as a speaker.
Let me understand something. So you are against dual citizens?
No, we are not. I am against the decision that members of parliament who are dual citizens should not serve as speaker. If they are qualified to be members of parliament, they should be qualified to be elected as speaker. They should be qualified.
The only reason why they do not want the only reason why they do not want them to become speaker is because he cannot be president. He cannot be president. And the speaker acts as president. That's the only reason. The speaker normally acts as president. The Chief Justice normally acts as president. As a matter of fact, I've acted as president over several times. You cannot have the dual citizen acting as president.
let us go back to the parliament. That will be defeating us. It will be defeating us. So what do you say? If you are coming from outside parliament, you should have served parliament for 2 terms. And if you are coming from within parliament, you should have served parliament for 1 term. If we don't state that as a member of parliament, you are not qualified to be elected as speaker because you have a dual citizen. How did you come to parliament? Your presence as a member of parliament qualifies you to be elected.
Hold on, let me hear.
Mr. Chairman, everywhere you took the president.
Yes.
Serious office.
Yeah, you have to be. Yeah, it's
serious office.
The president.
For you to be the
speaker.
that's what we did again. That's why just keep in mind the voluntary naturalization that you have voluntarily naturalized somebody as carrying who has
Yes.
So we otherwise have to make critical decisions on behalf of the state. And we are acting as president in the 2 interests. So we don't even want to we have placed a bar. We are president and vice president. You can't be president. That's the open provision. President and vice president. So we don't even want to act as president in person capacity. That's why we are putting Chief Justice and the Speaker of Parliament. Because you have acted, yes.
I don't think the people you are fighting for. I don't think they are positive like that. Because the point, what I'm saying, the only reason why the Speaker, the Chief Justice, Vice President, those positions are being accepted is because you cannot be a dual citizen and become the president of the nation. It's a matter of allegiance. It's a matter of allegiance. It's a matter of allegiance. You cannot be a dual citizen and become the president of the nation. In fact, it's almost all over. It's almost all over. So if we have a unique situation in Sierra Leone where we want to bring our brothers in, then we can still bring them in with certain safeguards so that we don't compromise the security of the state. With certain safeguards. That's the only reason why.
Mr. Chairman, if you let us speak Mr. Chairman, the position of a minister of a state, that is a sensitive position, very serious position. If we have allowed persons who have dual citizens to serve in that position as ministers, to serve positions as members of parliament, leaders of government business, how can we now say we don't allow them to serve as leaders? Don't forget, ministers negotiate contracts on behalf of the state. They come into agreement on behalf of the state. So if we are going to allow them to serve, it is like consequence of because they will get them to be qualified to be speaker, you should be qualified, you should be a member of parliament. How can you have a member of parliament and you now begin to draw the line between, oh, you are just MP, you know, to just MP, you are not qualified. If you are qualified to be a member of parliament, you should be qualified to sit in that.
Hold on.
Yes. We have this was voluntarily giving and it doesn't to be president. We have this in the world. There's no legal contract. Nowhere in the world. We know, not make ourselves funny. We are making this presentation funny. Are you saying we are American citizens or you are a citizen of Ghana, not to be a citizen of Australia? You are acting as a president. You are acting as a president. So, if there is submission, we continue to put restrictions on the seats. This is an exception. In other places, you cannot be in America. You cannot even be a member of the police force. When you have dual citizens, you cannot even be a member of the police force. So they are bad. This is complete bad. That you cannot be president and vice president. The reason why they are bringing chief justice and the speaker because they are acting in that capacity. Let
not be realistic. These are exceptional clauses. You are good. You are not an hour ago. Exceptional clauses. We are not making it 76 to be accepted. Yes, you can be a member of parliament, but it's under the domain of parliament and the president.
Yes, so if you want to be speaker, you go and
exactly.
If you want to become speaker, then you go and relinquish. You must talk about that. You go and relinquish
Yes, as Mr. Chairman, I think I agree with the minister and they are showing a bar. You can come to parliament and have that situation, but you cannot try to become a speaker.
The speaker, if you want to become speaker, you will not put your
it is wrong as a council.
Yes, the chief whip is still in place.
As long as there is a law,
yes,
you can come to parliament, you cannot try to be speaker. Or maybe the president at that time.
Yes, you can go and relinquish.
Exactly. That's why the second thing, Mr. Speaker, let us not talk about having a local tax for 5 years. As I'm talking to you now, my daughter is in America. I have local tax for her for the year. So that's not work. It's not work.
There's a different condition.
Thank you. You can take local tax even outside the country as long as they belong to that particular country. So that but I do with you and the speaker. Why do you want to be speaker of this parliament? Because I'm sure the speaker has acted as president more than twice. You cannot have
seven times. I have ruled you 7 times.
You cannot have somebody who has finished become a speaker of parliament. When you want to play for speakership, you go and denounce your I agree with you.
So, only Bashir sleeping. I don't think that is Mr. Chairman. Hold on. You can be qualified to become speaker, but you have to, even if you are a glass citizen, before you become speaker, you have to go and relinquish. Because when you occupy that position, you act as president.
I was a member, I was a chair for the when we are made decisions. And Section 78 Mr. Speaker, it says that if you are coming from outside Parliament, you should have served Parliament for 2 times or 10 years. So that if you are coming from within Parliament, you should have served Parliament for 1 term or 5 years. And a member of Parliament who have served Parliament for 1 term, or is coming from outside who have served for 2 terms. It is better we say let us go back and make Section 878 amended.
We cannot amend. We just say Mr. Chairman. Yes. Okay. Mr. Chairman.
Mr. Speaker, honorable members, so the restriction, if you hold...
Sergeant at arms, I told you to close the door, not so? That's a simple directive. Close the door. Only members of parliament are allowed to go out and come in. Carry on.
So the restriction, just to be clear, if you are a Syrian by birth, but hold the citizenship of another country, the restriction is actually for the presidency. So, which means you are getting the right to participate in the politics of the country, but noting that you have a restriction to occupy the presidency. Please, you have a restriction to act, to occupy the presidency. If you want to occupy the position of president, then you relinquish that additional nationality. Now, the reason why these other positions are coming into play, it's simply because these persons could act as president at any time. And so it is to ensure that if someone who is a Sierra Leone but holds the citizenship of another country gets into the political space, we ensure that that person does not act in the position of president. That is the only reason why Chief Justice and Speaker are coming in. Now, we do not need to amend Section 78, because while Section 78 there are very clearly persons who could be elected as Speaker, the restriction in 76 will apply if that individual wants to become Speaker. That is what this will mean. So we don't need to amend 76 because there is already a restriction in 76 which will apply to President, which will apply to Vice President, which will apply to Speaker, and which will apply to Chief Justice. That is what this will mean. Thank you, Mr. Speaker.
That's for page. Please, honourable members, I would rather want the leader of government business and the chairman legislative committee or the leaders to take the lead, because you debated, all of you debated. Because no, I don't want to open this thing to a debate.
Yes, sir. Mr. Chairman.
On this particular, what do you want to say on this matter?
No, Mr. Chairman.
We have read this.
Mr. Chairman.
Yes. Yes.
On this particular. Yes, sir. Mr. Chairman, I have the what result of the minister. The last time, one of the safeguards was about the contribution for the national security for the period of
course.
Yes, but when the new edition was pronounced, I didn't hear that.
No, that should be included.
Yeah. So it's still part of the
of course.
Okay.
Yes, Honorable Bakari. 1 minute.
I think we are actually getting entangled in this whole issue. So I am proposing that the best way to get ourselves out of we are now is that maybe we maintain the extant law. So essentially, how could you discriminate against someone who has been an MP maybe for 2 terms and yet has risen to the position of becoming speaker?
There is no discrimination. It's not a condition. There is no discrimination. You are free to become, but you have to nobody is on this matter. Nobody debate. It seems there is confusion. Hold on. Yes. Honorable leader. Yes, let me hear
I therefore move on suspending S05 so the business of the house will continue.
Any second All those in favor say aye. All those in favor say aye. Aye. Those against say nay. The ayes have it. Yes, leader. On this matter.
See, I started seeing the bureaucratic provision. Genuinely, we want to amend 76. I mean, those in diaspora, I don't think the intent is really for them to come and be president. It's really to give them space to really participate in our democratic process. It gives some leverage. You know, I've not seen anywhere where you have clearly voluntarily declared yourself to be a dual citizen in another country. Everybody knows about you. And you are going to be a president.
Yes.
No, maybe after a president, Yes. So we need to be careful. It's a serious business. The AG has advised us. Yes. He's a legal advisor. No matter what you say, he said these are exceptions. He brought his amendment. He said these are exceptions. It cannot be. So we have to place some seriousness in the legislation. That's just that. So I appeal to my colleagues, deputy leader, that because we are not giving in, initially we don't access them. We have to start somewhere. And even when I reminded him about this, he said he will now amend. I said, when you do something, you take care of this because so we are going to look at all these provisions. So cannot be a damn with the extra law. Yes,
proceed. We proceed. That's for page 14, page 15. Is it still on this point? No, Honorable Bashir, still on this point?
I still believe we should amend section 17. I might not win, but let me just say this my position. And it should be yes. Section 78 was amended by all of us. This parliament, it was amended. I know, Mr. Speaker, Mr. Chairman, honorable members, when we came to this parliament in 2012, we had a lot of persons coming from the diaspora who were members of parliament. And after today, Mr. Speaker, nobody will question who has citizenship or not. All of us will have to contest elections. Then people will have to contest elections, and they will come, and nobody will have to declare. Nobody will have to declare that, oh, we also to me that 15 or hours. We are out there.
Of section 78. Do you want an
that is the qualification of the
Mr. Speaker.
It is amended.
Read section 78.
Section 78 reads.
Read section 78.
Section 78 reads. So it is not here. You cannot be amended, sir.
Point of order. 34. The side note has to do with the High Court. Mr. Chairman. Mr. Chairman. Our colleague needs to understand. Yeah. So no, Mr. Chairman, my colleague needs to understand. You know, you just want to when you push. Somebody said if I love just maintain instant position. Basically, our fellow citizens abroad to participate in the electoral process. But you cannot see a committee to be an American, to be something you want to be president, you want to be speaker of parliament. There should be a bar.
So that when
there should be a bar.
So that you are almost always in America.
If you go, you're right. You're right. Because you're not citizen. You're right. Colleagues, the minister, please. The minister has proposed for us. He has made the position very clear that let us accept the amendment and propose an exception. Let us move forward. Our colleagues in the diaspora, I think what they propose, what I have from there, I have a text on there. That they even talk about if you have 5 years, nothing. Because all those things, they are never mentioned that you want to be president. Yes. If you want to be president, recuse yourself. Yeah, of course. Don't apply that, so my allegiance is gone. I'm now purely Australian. I don't have to do a anymore. Let's talk about say, let a nation beyond this function of Australia, let us see us as a serious legislator that we are putting a power on presidency. Of course. These are positions when you are in here, nobody can stop you.
Let the proper rendition be done, man. Let the proper rendition be done to that effect. That's on page 14. Page 15. Page 15.
Yeah. Mr. Speaker, actually I'm pleading, and I'm sure our minister will agree with me. And I'm talking about where members are obliged to resign from public office at least 6 months before the date of election. Let me land, please. Let me land. No, we did not. No, am I protected?
protected. But we passed that already. Let me hear you.
Yes. Okay. Hear me, Mr. Speaker. Mr. Speaker, we have our, government workers, like the police, like the military, like the nurses, who intend actually to come to Parliament one day. And their salaries will not allow them to resign 12 months before such a
Page 15, page 16.
Page 16, Mr. Chairman.
Page 16, yeah.
Let's see.
16.
I'm still on page 15.
Yeah, what is it?
Let's just be clear here because, again, top part where they mentioned the Anti-Corruption Act of 2008, we already.
Yes, proceed.
Yes, the page 15, just a reminder that we took from the mid to the bottom part of it to the Public Elections Act.
Yes, Honorable Conte.
Yes, if you can recall, starting from C, the AG made that clarification, what you have in paragraph H, it was a mistake, it becomes paragraph E. So, again, Mr. AG, in page 15, just for the records, remember we had H, but again you came up and said it was paragraph E.
Yes. Yes, take note of that, AD.
Yes, Mr. Speaker, Honorable Members, that is amended.
Yes, and the bottom aspect of it was moved to what we agreed to move it to the Public Elections Act.
That's for page 15 also?
Yes, 2.
Is that noted?
That noted.
That was.
We dealt with all of these provisions.
Yes, no, Mr. It's the confirmation, you understand?
Okay, yes, take note of that.
Like you said, we were paid by paper, the confirmation.
Yes, Mr. Minister, take note of that. Now, page 16.
And page 15.
Yes.
Like, just a clarification for the agency.
Yes.
We are talking about 2 plus 2. We talk about E. We're talking about election-related offences. Somebody being debarred for 12 months, a bit competent for 12 months, and should not participate. We can the AG, because election-related offences is not, is for me, it's so big, it's not
don't have no qualification for that. It can be minor, it can be major, it can be. So when it's
minor, major, as long as you have been convicted,
yeah,
they should not qualify.
Mr. Chairman, like my argument here is we talk about the dropping of charges or cases against presidential candidates for political reasons or non-political reasons. So we can qualify that both civil and political. Now, it now comes to election-related offences, and we are all politicians. Somebody somewhere will just look at you at one point and say you committed XYZ because of Mr.
Let me talk to you on this. You see, when you make laws, these minute details about life, you cannot put into law. If you want to take care of everything in the law, you will never end. It's a minute thing. You see, somebody can just come, redeem me, and they take you to court and they convict you. Put up any test. You put up any test.
Mr. Speaker, if I may.
Yes,
if I may, when we put disqualifiers in laws, it's only when they are established such, let us say for criminal conduct, if someone is disqualified for criminal conduct, it's only when that is established that the guilty. It's not when somebody points to you that you've done this. It's only when you have been convicted.
And you have to go to court and convict.
Exactly, and the point is, we have also included language to read that these are offences for which someone will serve jail time. Yes. These are not offences for which the sentences can be even substituted by fines.
Yes.
Again, if I may add, Mr. Speaker, honorable members, as kindly corrected, whilst I argued strongly that this provision is set in the Constitution, I think the leader of government business had moved that this provision, this proposal, be moved to the Public Elections Act. So I think where we ended with this was the removal of two from this bill. In any case, Mr. Speaker, I also want to add, I think I need to provide clarity on this issue of elections-related offences because I think the Deputy Leader of the Opposition raised the same issue. Actually, in the Constitution right now, when we see the extant law, yes, election-related offences are there. Yes. They're there. If you are convicted of fraud, dishonesty, or election-related offences, you will be disqualified. So basically, we were just expanding the scope. Right? We were just expanding the scope, but I think this House has resolved that this expansion be moved into the Public Elections Act.
Okay. Now, yes.
I understand exactly what the minister is proposing, but if you say elections, related offences. Let me cite an example. I was petitioned in 2018 election. Our APC won the 2018 elections. I was going to be removed. Why? One of the grounds of the petition was there was a fight at the polling center and I was there. And so then it was an election-related offense that should have taken me out of this parliament because I was there and I was a candidate. So it is too vague. Because as you are saying, Mr. Speaker, that even how small the offense is. When your opponent wants to go against you, and you are a strong force, they can bring allegations that and they can win in court. We all know the court. So, I was going to be removed.
When you have your right, allow nothing wrong to say no the constitution. Nothing wrong. It depends on your opinion.
If you don't have evidence, you lose.
Mr. Minister, let me hear you.
I think, Mr. Speaker,
yes.
First of all, the Public Elections Act, offences are listed.
Yes.
They're not vague.
Yes.
Election-related offences are specific. If they are not outlined in law, you cannot be charged or prosecuted.
But I think this one is part of those laws.
Exactly. But also, Mr. Speaker,
I raised that in the Elections Act.
Yeah, you can raise that, when you look at the sections that outline offences that are termed as election-related offences. But also, Mr. Speaker, I think we need to establish one thing. Again, I say, when we last discussed these proposals, my understanding was that we settled on they move into the activity to move them to the Public Relations Act. Again, is the position of this House that these proposals be discussed in the context of the bill, then let's discuss them. But if it's the position of this House that these should go to the Public Elections Act, then I don't think we should be discussing them now. We can wait for the Elections Act.
So, Chairman, the reason why
yes,
leader. Because he made a very salient point, which there are reasons for some of these trials not to really state the Constitution, because we have to deal with them for conviction. The issue here is conviction. When you are convicted, you don't contest the conviction. That is clear. But the reason that I brought to you before why we should take the public elections, because I give on behalf of rape and sexual penetration. And I said that law, as I speak, not supposed to do so. There is an administration that's supposed to do as a nation, we have not done. The administration of forensic testing. And by the time you want to go and charge terrorism, it's something like so he says, be in the Public Elections Act. Tomorrow, by the time you can broaden into the election violence, in fact, the election violence or election offenses, they are well attached to the Public Elections Act. Whether you are the seat or not, those things are very, very clear. So for me, we should move them. I think the age has been on serious, but what should maintain, and not going to say in the Constitution, when you are convicted, now we are not saying because we have to keep such offenses. Let the new ones come in, stated, the rape and sexual penetration, let me treat them in the Public Elections Act. So we can exhaust extensively before taking decision in terms of that's our offenses that in fact things that are bad in our country. So the most serious can be accepted. So that's what we are saying. So at the end of that, we can again review for every election the dynamics. We can review the election offenses and we brought it up to see what are the election offenses coming up as 3 months. Let's look at the acts and the other special amendment of the Public Elections Act. Okay. Page 16. Are we okay with page 16? 16. Page 16. Yes, Honorable Mustafa.
Still, 16 is a follow-up from 15. 3. Its qualification under subsection 2 shall end. A. 5 years after the sentence has been completed, or the person is pardoned.
We deleted all of those. We deleted all of those. In fact, all of page 16 and page 17.
Why not? Yes.
Okay, we maintain clause 17 onwards. So we only maintain, in fact, let's just debate on 17 and 18.
Clause 17.
No,
Speaker, before that.
Yes, Mr. Minister.
Yes, so if I may, with your leave, Mr. Speaker, still on criminal conduct. First, let's note that certain criminal conducts are listed in the Constitution, which will disqualify someone from serving as a member of Parliament. 76(1) D says if he has been convicted and sentenced for an offence which involves fraud or dishonesty. And then E, which we have proposed to delete now, says if he is under a sentence of death imposed on him any court, because we have no, I'm looking for the Constitution. because we've abolished the death penalty. And then Section 76 of the Constitution, subsection 2, says a person shall not be qualified for election to Parliament if he is convicted by any court of any offence connected with the election of members of Parliament. Mr. Speaker, I just want to add that we note the specificity on D, fraud or dishonesty. So now we can say corruption-related offences. But I just really want to go back to cabinet. The seriousness that cabinet attaches to persons who have been convicted for offences like treason, murder, manslaughter, rape or sexual penetration were particularly important to His Excellency and the rest of the members of Cabinet. So my question would be that yes, there are broader offences, especially relating to, say, the provision said if someone has committed an offence for which they've served a sentence of 12 months, minimum 12 months, then they will be disqualified. Is it possible to say, yes, the proposal on 12-month sentence does not come into Constitution, but because the Constitution, the extant law, is specific on fraud and dishonesty, and the seriousness that we attach to rape and sexual penetration, murder or manslaughter and treason, is it possible to keep these three categories of offences within the Constitution? Categories.
Yes, I think the still try to draw attention to 76. Now, if you look at 76, it's really limited in terms of offences. You don't mind that.
Yes.
76, Chairman. Let me read so that we can. First, we can talk about I've accepted the proposal for completion. But how do we deal with cases of sexual penetration? How do you dishonest? Let me dishonest. Let me read 76 D. Let's start with D. We said if he has been convicted and sentenced for an offence which involves fraud or dishonesty. So for us, we can hold this one as an example law, but in the public elections, we now this what are the things that support dishonesty? And fraud. What do we consider fraud and dishonesty? We put it in the public elections as clearly. In fact, that is one. And under offences, what you have stated again, we can broaden it up. Other issues that related to sexual penetration, even terrorism. The one that we need to remove is the death penalty. We don't need it anymore. Now, because they said we have amended death penalty. So we can really now give conviction. Because said if he is under a sentence of death, the normal person basically. So we want to be consistent with what you have done. We are repeating the death penalty from the Constitution. Imposed on him or by any court. So we need not to have this one. Chairman, are you with me? The death penalty should not start.
The only thing is that I think you are all missing the point. This is something we expedited.
No, he brought in fraud.
It's already in the public elections act, it's in the Constitution. I don't know why
he is making reference to this. But fraud is both fraud.
What is it of this one? Yeah, of course.
The E is gone.
Yes, everything is gone.
No, D is not gone. What he is saying, he wants us to maintain D as a thing.
That one is already in the Constitution.
Yes. So what when we come to public elections and we itemize them?
Okay, when we come to that. Also, yeah, well, let's not discuss this. We are taking this to the public elections act. Maybe to label the point of this.
What do you
we should only deal with clause 17 and 18. Yes. 17 and 18.
Mr. Chair,
Chairman, even 17 and 18, debate on that. Yes. It was about the issue of proportionality for the police and military, and we are very clear about the rules of conduct. Of course. So again, but I think here in 17, 18, the clause I was looking out for the provision that we understand that the Electoral Commission is here, act in a partisan manner. I think we put it here for the police and military. Yes. So we can get that in order to Chief Electoral Commissioner and act in a partisan manner. Okay. Thank you very much.
Mr. Chairman, I want to give you feedback.
Mr. Speaker, I've confirmed with the General Government Business and those proposals were expunged and moved to Public Elections Act. We have been at the stage that way. Thank you.
Yes, thank you. So we are done. Mr. Minister, can you now move?
Mr. Speaker, Mr. Chairman, honorable members, I move that Part 1, clauses 1 to 18 stand part of the bill as amended.
Honorable members, the question is that parts 1, clauses 1 to 18 stand part of the bill as amended. All those in favor say aye. Aye. Those against say nay. The ayes have it.
Part 1, clauses 1 to 18 form part of the bill as amended. The House resumes.
There is Mr. Minister report.
Mr. Speaker,
Hold on. You know how many minutes? Let's go. Honorable Mara, please, Mara, please go. Honorable Mohamed Bangura, please come. Honorable Mohamed Bangura, members, this sitting is stood down for 20 minutes. Please make sure, go fresh enough and come back in 20 minutes.